Now, police officers implicated in the murder of 16-year-old Nathaniel Julies have admitted to firing the shot which ultimately took his life. Kaylin Whiteboy made the confession in the Protea Magistrates Court in Soweto, where 3 police officers are seeking bail. The Eldorado Park teenager with Down syndrome was killed last month, and his death sparked outrage in his community. Here's Mbali Tetani with the details.
Explosive revelations were heard in the Protea Magistrates Court, finally giving some answers to the family of Nathaniel Julies and how he died. Police officer Kaylin Whiteboy claims when she fired the shot, she was scaring off 16-year-old Nathaniel Julies.
Unbeknown to her, when she fired, she realized by the force and the pressure of the reaction of the shotgun that it was now no longer loaded with rubber bullets, but it was loaded with live rounds.
Whiteboy, through her affidavit, told the court that she had used the shotgun earlier in the day to disperse a crowd. She says it was initially loaded with rubber bullets. Whiteboy has also told the court that fellow policeman Scorpion Simon Ndalwane, who had been accused of the crime by the community, has been threatening her life if she reveals the truth.
I also received written WhatsApp death threats from my co-accused number 1 as a result of my endeavor to cooperate with the state in ensuring that the whole truth is told here.
What is she saying? She says applicant number 1 is threatening.
Yes.
Oh. He's threatening to kill her. What?
Threatening to kill her if she tells the truth.
Scorpion has pleaded his innocence, saying it was not his firearm that killed the teenager. The bail hearing continues. For Newzroom Afrika on Channel 405, I'm Mbali Tetani in Soweto.
Joining me now to discuss some of what we're hearing coming out of that case and, of course, the charges, Ulrich Roux, the Managing Director of Ulrich Roux and Associates. Ulrich, good evening and thank you very much for your time today. Of course, this is a matter that is still in court, so we're treading very carefully in as far as what we are asking. But what we are hearing coming out of the courts today is that a firearm, shotgun that was fired earlier on to disperse a crowd had rubber bullets in it and was then fired again later on that day. It seems to now have live ammunition, and it was fired by police officers on duty at an innocent child who is, well, allegedly innocent. That's what we are assuming at this point from what we're hearing from the community. And of course, the courts will have to determine what was actually going on there. But he was non-threatening. What are the implications?
Hi, good evening. Thank you for having me. Yes, certainly interesting revelations today during the bail application. You know, if one was to go on the version of the police officer who shot the minor child, then it is a form of gross negligence in handling that firearm. I mean, for a police officer who is supposed to be experienced in the handling of riotous behavior or unruly crowds, not knowing that she's got live ammunition in her firearm and thinking that it's a rubber bullet is negligent in the utmost degree. So, you know, it's tantamount to a confession, in my opinion. Also, she obviously is being charged with murder, and the state could be alleging that, you know, the fact that she should have foreseen that firing that bullet at the minor child could have led to his death, and she reconciled herself with that fact and still did it, which is obviously the charge of murder dolus eventualis. So certainly interesting revelations coming out today, and one would have to wait and see whether the court finds them as candidates who are suitable to be released on bail.
Broadly speaking, then, in terms of the law, what is the expectation, what is expected of a police officer and any individual handling a firearm, be it a firearm that contains rubber bullets or contains live ammunition? What is the expectation in law of what that person should be knowing and be aware of?
Well, remember that any person who handles a firearm is supposed to have undergone a competency test in order to handle that firearm in a responsible way. And especially if you're a policeman or a policewoman, then that threshold and that test is just so much more important because you will be handling your firearm during the scope of your duties on a daily basis. So certainly, the requirement for the responsible handling of a firearm has not been met by her, not only in her scope as a police official, but as a person who handles a firearm in the normal course of events as well. Of course, the laws that apply to normal citizens also apply to police officers, and if they are found to have handled a firearm recklessly or negligently, and it was not in the course of defending themselves or someone else's life, then of course the charge of murder would be a valid one, and the onus would be on the state to prove that charge, of course.
When we speak of the handling of live ammunition directed at a crowd that is protesting, directed at a child, a minor that is suffering Down syndrome, the question then becomes, and that's the one that came to my mind when I was hearing that testimony, is why fire in the first place if the situation is non-threatening?
No, exactly. When there is a death of a person as a result of a firearm, your only defense would be that you were acting in self-defense and that you had to take the action that you did in order to protect either your own life or the life of someone else. And as you correctly pointed out, there is no way in which this police official, as well as the other two accused, could try and allege that their lives were in danger by the 16-year-old minor child. And it would be quite interesting to see what defense they are actually going to try and come up with. The defense of self-defense and claiming self-defense as a reason for your actions is a very difficult one to prove, and they would have to prove that their action was in accordance with the threat that was posed.
And of course, the angle that is being taken by the officer who discharged the firearm is that, well, I was given direction by my superiors, because she is apparently, according to the testimony, new on the job, only been an officer for a year, and the superior is the one who gave this direction. What is the implication there?
Well, if the superior if it can be proven that she acted solely on the instruction of the superior, then the superior should be co-accused together with her. But that does not take away from the fact that she was the person who was handling that firearm, it could count as a mitigating circumstances after she has been found guilty in order to try and receive a lesser sentence. But it certainly does not detract from the fact that she was the person who was handling that firearm when an innocent minor was killed through her actions. And that is the facts of the matter.
And as far as our laws are concerned, and what's your view in terms of they are tight enough and they protect enough of the innocent citizens from being shot at by police whenever the police, feel like shooting, it seems?
Yes, definitely. Our police force is supposed to be there to protect society and to protect communities. Obviously, if there is dangerous riotous behavior, then the police need to take action which is in line with the threat that is being posed. And that is the most important question, is how did it come about that there was live ammunition in that shotgun and not rubber bullets? So severe negligence in that case. But secondly, you don't just shoot at a crowd or at a minor or someone who is not posing a threat to your livelihood. Pulling a trigger of a firearm should be the absolute last resort. And it is apparent that in this instance that was not the case, that the police official who did use that firearm did so without a real threat being posed to her, and it has cost the life of an innocent person. So certainly serious repercussions that are going to follow, and a very serious decision that will have to be made by the court in deciding whether these officials are granted bail, but ultimately also during the trial of the matter, because a message must be sent out to society as well as to police officials by our courts that when a person decides to handle a firearm, they must be 100% sure and certain of their competency to do so, and they must be 100% sure that an incident such as this will be avoided at all costs, and that innocent people will not be losing their lives as a result of the negligent or reckless handling of a firearm, as is apparently have been the case in this instance.
Ulrich Roux, appreciate your time. Thank you very much for joining us tonight. Managing Director at Ulrich Roux and Associates.